Okay, let's dive right into this. Welcome to today's explainer. If you're a law student, a practicing lawyer, or especially if you are currently gearing up for the bar exams, you are in exactly the right place. Today, we're breaking down a really monumental Supreme Court and bank decision, People v. Sapla. Honestly, this case is an absolute must-know. It serves as a definitive explainer on the probable cause doctrine, specifically when it comes to anonymous tips and warrantless searches. We're going to unpack exactly how the court balanced the state's aggressive campaign against illegal drugs with our fundamental constitutional right against unreasonable searches and seizures. Here is our quick roadmap. We are using a modified IRAC structure because, let's face it, that's exactly what you need to make this stick for your exams. We've got 1, the facts, 2, the issue, 3, doctrinal evolution, 4, the court's definitive ruling, 5, concurrence and dissent, and 6, final bar takeaways.
All right, part 1, the facts, the checkpoint, and the blue sack. Let's set the scene.
The story unfolds on January 10th, 2014, and I want you to look at how incredibly fast this timeline moves. At 11:30 a.m., police get an anonymous phone call claiming a guy is transporting marijuana into Isabella. Then, at 1 p.m., they get an anonymous text message on their hotline. And this text is super specific, right? It says the suspect is wearing a white collared shirt with green stripes, a red cap, and he's carrying a blue sack on a specific jeepney. Just 20 minutes later, at 1:20 p.m., police flag down that exact jeepney at a checkpoint. They spot a man perfectly matching the description, Jerry Sapla. They ask him to open the blue sack, they find 4 bricks of marijuana, and boom, they arrest him. Now, pay close attention to this part. The police relied literally, entirely on an unverified text message. They didn't do any surveillance, they didn't witness a crime happening, they just read a text from an unknown sender and acted on it.
Which brings us to part 2, the issue, anonymous tips and searches.
The lower courts actually convicted Sapla, but the Supreme Court en banc stepped in to settle this massive legal question. Can an unverified anonymous tip justify a warrantless intrusive search of a moving vehicle? This right here is your golden question. If you're drafting a bar essay on this topic, this is the exact issue statement you want to formulate. Does a solitary text message give the police the green light to dig through your personal belongings in a public vehicle? Let's move to part 3 and see how this builds doctrinal evolution, unpacking the precedents. To really understand the court's answer, we can't just look at Sapla in a vacuum. We have to trace the judicial evolution of the probable cause doctrine. We all know the textbook definition. Probable cause is a reasonable ground of suspicion supported by circumstances sufficiently strong in themselves to warrant a cautious man's belief. Now, a routine checkpoint allows for a visual search, sure. But if the police want to conduct a more extensive, intrusive search of a vehicle or your bags, they absolutely must meet this standard of probable cause. Bare suspicion? A mere hunch? Not going to cut it. They need articulable facts. For your exams, you absolutely have to know these 2 major precedents that set the stage for Sapla: People v. Comparjato and People v. Janssen. In Comparjato, the court laid down that if the police receive a tip about a specific person on a bus and they board that bus just to search that specific person's bag, well, the moving vehicle exception doesn't actually apply. Why? Because the target is the person, not the vehicle. And then in Janssen, the court made this massive sweeping declaration. A solitary anonymous tip, without any other suspicious overt act by the accused, is just bare suspicion. And as we know, bare suspicion never amounts to probable cause. You need a confluence of circumstances, not just a single, unverified hint. I really want you to absorb this quote from the Janssen ruling. Exclusive reliance on information tipped by informants goes against the very nature of probable cause. So what does this all mean in the real world? It means that if the courts allowed intrusive searches based solely on anonymous tips, it would literally open the floodgates. Anyone could hide behind a veil of anonymity, send a totally fake text message, and subject their enemies or their neighbors or completely innocent people to police harassment and highly invasive searches. Let's transition to part 4, the court's definitive ruling. Application in People v. Sapla. So let's see how the Supreme Court applied these evolved doctrines to Jerry Sapla and his blue sack. The court started by drawing a very hard line between a legal routine checkpoint and an illegal extensive search. At a routine checkpoint, police are strictly limited to a visual inspection. They can look through the windows, maybe flash a flashlight, but the exact moment they demand you open your bags and they start rummaging through your personal effects, that becomes an extensive search. And as we just established, an extensive search requires probable cause. In Sapla, the court found the police clearly went way too far. The court broke down its reasoning by highlighting 3 major flaws. First up, applying compredo. This was not a valid search of a moving vehicle. The police weren't searching the jeepney itself. They were explicitly targeting Sapla based on his shirt and his cap. Second, applying Janssen, the solitary tip was incredibly weak. It was actually double hearsay. Just think about that. It was an unverified text message sent to an unofficial phone, which was then read by a duty guard whose name the arresting officers couldn't even remember. And third, what about consent? The prosecution tried to argue that Sapla voluntarily opened the sack. The court completely rejected this. Let's be real, when you're flagged down at a checkpoint and surrounded by armed police officers, your consent is vitiated. It's not voluntary. It is mere passive conformity to a highly coercive environment.
Because this search completely violated Sapla's constitutional rights, we trigger one of the most powerful doctrines in criminal law, the exclusionary rule. You probably know it as the fruit of the poisonous tree doctrine. Because the initial search was illegal, those 4 kilos of marijuana discovered inside the blue sack were deemed legally non-existent. They were absolutely inadmissible in court, and without that physical evidence, the state had no case, which inevitably led to Jerry Sapla's acquittal. Now, as a savvy law student, you might be wondering, wait a second, what about the Salute case? Didn't they allow a bus search there? Excellent question. The court very carefully distinguished Sapla from Salute. In Salute, the search of the bus was minimally intrusive. They literally just lifted a suspiciously heavy bag. And, importantly, it was applied non-discriminatorily to all passengers strictly for public safety against terrorism. In Sapla, however, the search was deeply intrusive. It selectively targeted one specific man based on a solitary tip, and it was solely to find drugs, not to protect the immediate physical safety of the passengers on that jeepney. Huge difference.
Moving on to Part 5, Concurrence and Dissent, the divided court. It's important to note the Supreme Court was not entirely unanimous here. Understanding the differing viewpoints gives you incredible depth for your legal analysis. Justice Leonone wrote a really powerful concurrence supporting the majority, emphasizing that we absolutely must protect the Constitution over mere law enforcement expediency. He argued that allowing searches based on solitary tips completely fails those strict guidelines set out in Salute. But on the flip side, Justice Lazaro Javier offered a really compelling dissent. She argued that the tip actually was verified by the exact visual match of the passenger and his bag. Her stance highlighted that police officers' on-the-spot field judgment calls should be trusted, and that effective law enforcement is a legitimate state interest that shouldn't be entirely hamstrung. It is a fascinating look at the objective balancing act the judiciary has to perform.
So, the crucial point is right here. Part 6, final bar takeaways, what you need to remember. Grab your highlighters.
Before we hit those final rules, I want to leave you with this incredibly profound quote from the Panintia penned by Justice Kagiowa. The Bill of Rights should never be sacrificed on the altar of convenience. It's such a stark reminder that the end does not justify the means. Eradicating societal diseases like illegal drugs cannot come at the cost of trampling the fundamental, inalienable rights of the people.
All right, here are your ultimate doctrinal rules to take away. 1. The moving vehicle exception does not apply when the police are targeting a specific passenger and their personal luggage. 2. Unverified anonymous tips alone never, ever constitute probable cause for an intrusive search. You always need a confluence of suspicious circumstances. And 3. If the state claims a suspect consented to a search, they must prove a valid, intelligent waiver of rights, not just passive conformity in a highly coercive environment. Mastering these 3 points will make your legal analysis absolutely bulletproof. But it leaves us with a critical question to ponder, right? As technology makes anonymous reporting easier than ever before, how will the courts continue to draw the line between public safety and the fundamental right to be left alone? Let me know your thoughts down below in the comments. And hey, if you found this breakdown helpful for your studies or your law practice, please make sure to comment, like, and subscribe for more legal explainers. Thanks for learning with me today, and I'll see you in the next one.